Laid off on an H1B? Well, it's not just a job loss, it feels like your entire life is on the line. But here's the truth, you have more options than you really think. Today, we are going to talk about how you can stay in the US legally and plan your next move with confidence. Hi, I'm Saiman Shetty, the founder of Smart Green Card and an EB1A recipient myself. Over the past few years, our Smart Green Card program has helped more than 200 professionals achieve their EB1A approval through ethical, strategy-driven support. And let's get straight to the topic of today. If you've just been laid off while on a work visa, I know that sucks. I want to start by saying this, you're not alone. Thousands of immigrants are going through this right now, especially given the economic and political climate. And I know how overwhelming it can feel. Your visa, your job, your family, your plans, everything tied to just one moment, which is your employer. But this video is more meant to serve as your step-by-step guide to understanding your options. So what really happens the moment you're laid off on an H1B? Technically, your H1B status is tied to your employment. So when your job ends, your period of authorized stay based on that employment ends as well. However, you're not immediately out of status. USCIS provides a 60-day grace period or until your I-94 expires, whichever comes first, during which you can actually remain in the US legally and take steps to maintain your status. During this time, you can find a new employer and file a transfer. You can apply for a change of status like to a B2 or a F1. You can prepare to leave the US. The key is that you must act within that 60-day window to maintain your legal presence. Option number one, though, is to get a new H1B job. This is what most people try to do. This is the most common path. Find a new employer willing to sponsor your H1B. Thanks to the H1B portability under AC21, you don't have to go through the lottery again. And here's how it works. Your new employer must file a labor's condition application or an LCA. After the LCA is certified, they must then file a form I-129 with USCIS. And once USCIS receives the I-129, not just the LCA by the way, you can legally start working as long as your current H1B status hasn't expired and you're still within the grace period. Here's an important point. You cannot start working just after the LCA is filed. The I-129 must be submitted to USCIS before you can start working. It takes about 7 days or a little more to get an LCA certified, so you can start this process at least 2 weeks before your grace period ends. The second option is to switch to a different visa. If you're not landing a new H1B job fast enough, don't really panic. You may still have other options to stay in the US legally. The B1, B2 tourist visa is an option. So you can file the form I-539 to request a status change to a B1, B2 visitor visa. And if approved, it may give you up to 6 months to remain in the US while you passively explore next steps, such as researching programs, attending networking events, or even preparing for your next visa strategy. Here's an important point you need to remember. USCIS has become stricter with the B1, B2 change of status requests after an H1B layoff. Approval isn't really guaranteed, your intent matters, and strong documentation is key. Then there is the F1 student visa. If you're thinking about a career pivot or going back to school, and if you get accepted into a SEVP certified program, you can apply to change your status to an F1 and continue staying in the US legally as a student. And then there's the H4 dependent visa. If your spouse is on an H4 or another work visa, you may still be eligible to switch to an H4 dependent visa. And if your spouse is at a stage where they have an approved I-140 already through EB2 or EB5 or EB1 or EB3, whatever it is, you could even apply for the H4 EAD and continue working legally. Now, all this said, if the EB1A process feels overwhelming, we've got you. Our Smart Green Card program's VIP plan isn't about dumping PDFs on you and walking away. We help you study your profile, we guide you step by step, and we help you potentially meet at least 5 criteria plus final merits as well. You get organic press support, your publication support, your judging opportunities, and way more, all tracked in a smart dashboard. And once you are about 75% profile ready, we will even connect you with vetted US attorneys at discounted rates that we have in our trusted network. No fluff, no confusion, just real personalized support. Join the VIP plan now. The link is in the description. So what if you already filed the I-485? If your employment-based green card, which is the form I-485, has been pending for 180 days or more, you can actually switch jobs as long as the new role is the same or similar occupational classification. You may also qualify for an E-8 or an employment authorization document which allows you to work freely while your green card is being processed. But here's the catch. If your I-485 has been pending for less than 180 days, changing employers can jeopardize your green card application. That's because the portability rule AC21 only applies after the 180-day mark. In that case, speak to an immigration attorney immediately. Porting might still be possible, but it requires careful legal strategy and timing. I know this is a lot to process, but remember, losing your job doesn't mean losing your visa. You still have options, rights, and a future in the US. If you found this useful, like the video, share and subscribe to the channel. Share this with someone who just got laid off on their H1B, and it might save their future and their financial situation as well. And if you're ready to take real action, check out smartgreencard.com. Your next step starts there. This is Saiman Shetty signing off. You come this far, let's make sure you stay for the long term.